All right, court is calling 2022 CR 2514 State versus Deja Garcia. Could I have parties announced?
Megan Galloway for the state.
Teresa Max Vasquez for the defense, Judge.
And are you Deja Garcia?
Yes, ma'am.
All right, Ms. Garcia, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Deja Rosset
Yes.
Garcia who was placed on deferred adjudication in 2022 CR 2514 for the offense of attempting to take a weapon from an officer on May 26, 2022 for a period of 3 years? Is that you?
Yes.
All right, state.
Violation of condition number 41 on or about the 17th day of April 2025 in Bexar County, Texas. The defendant, Deja Rosset Garcia, did then and there fail to comply with the rules and regulations of the felony drug court by tampering with drug patch in violation of condition number 41.
How do you plead?
Quick pause. What you're hearing is a probation violation hearing. The court gave Deja a second chance with deferred adjudication, basically probation without a conviction on her record. But now the state says she tampered with a drug patch. Do you think that's a serious enough violation to revoke probation, or should the court be more lenient?
Is that true or not true?
Not true.
Okay. All right.
I guess I need to talk to the attorney because I thought something different was happening.
Okay.
We could just step back for
Sure.
5 seconds. Just, yeah. Judge, if I could, well, we're going to go back on the record.
Sure, we're
I'm
back
going
on
to
the record.
withdraw the condition of violation of condition number 41
Okay.
and proceed on violation of condition number 2 on or about the 31st day of March 2025 in Bexar County, Texas. The defendant, Deja Rosset Garcia, did then and there admit to consuming alcoholic beverages.
Whoa, that escalated fast. By admitting to drinking alcohol, Deja just triggered the maximum penalty of 2 years in state jail. This shows how even what seems like a minor slip, just drinking, can completely undo years of progress in specialty courts like drug court.
Is in violation of condition number 2.
How do you plead to that? True or not true?
True.
And then we waive and abandon the remainders, Your Honor.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there a proposed agreement?
There's not, Your Honor. The state is asking that you grant the state's motion, revoke the defendant's community supervision, adjudicate her guilty, and sentence her to 2 years in the state jail facility. She was placed on deferred adjudication back in May of 2022 and was a participant of felony drug court until this recent MTR where she was not in compliance with the program. And so that's why we're asking for the 2 years in the state jail facility.
All right. What are you requesting?
Yes, Judge, we are asking the court to consider the recommendation of the probation officer. We did confer with probation and their recommendation, as far as I understand it, is to reinstate her with the DDRF. It seems, as far as I understand, Judge, after talking to my client and reading the report, is that she did well on DDRF. She did not do well on safety, is what I understand. So I've had communications with her. I have an understanding, a little better understanding of DDRF and the difference. And she does feel that she benefited more with the dual. That includes the mental health
But
component.
didn't felony drug court have her on the dual track?
They moved her. That's a good question, Judge. I believe they moved her from the DDRF to straight safety, is what I understand. And that's where she
Didn't want to go to safety.
went astray, I believe.
So you didn't want to go to safety?
I just signed on it, cause just wasn't in the right state.
You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Deja Garcia.
So felony drug court, didn't they have you in their dual diagnosis program?
Yes, ma'am.
All right, so where are you saying you went off track?
Right, a few months after I got out of DDRS, I got off track again, and that's when they decided to have me sign the safety.
Okay.
Because it was about after 4 or 5 months.
Did you go to safety?
Yes, ma'am.
All right. Did you successfully complete it?
Yes.
All right. So then you get out of safety. Then what happens?
I slipped up and I drank like on 2 of the violations.
So why did you drink?
Um, I think just because I was kind of overwhelmed when I got out of that facility. So I'm not trying to make it an excuse, but I was just overwhelmed.
All right. So to the court, and if I'm wrong, let me know. There seems that there's more than just this being overwhelmed, because I used to be an attorney in felony drug court. And when you're released from safety or some kind of inpatient treatment, they don't just let you fly free because they know you're going from a lockdown facility to coming out. So they really keep track of you until you're on the right path. Then they let you be freer with your time. So I'm not understanding. So you leave safety and you start drinking.
Yeah, ma'am. A few weeks after I get out, I drank like once or twice.
Mhm.
I just had a lot of
Can I say something, Judge?
Sure.
Okay, so I spent a little time with her and I don't know if maybe she's not remembering or the communications we had, we went over the excuses and how just give them the facts and tell them what happened. What I see in this is, I asked her, how did it happen? What happened? What was your plan? What was the goal? How did it work after you got off? You got out just like you just went through with her. What she hasn't said was that she tried to enroll in school. She moved back home, I believe, correct, with your parents. And so that's where we stopped. I think it was a few months ago.
Well, here's the thing. When you move back in with your parents, the felony drug court approved you moving back in with your parents?
no, ma'am.
All right. See, that's part of the problem because felony drug court has rules where you can stay, what you can be doing. When she got out of inpatient treatment at Safety has an aftercare program, which is what she's supposed to be in, and felony drug court would still keep track of her. So this thing right now, what she's doing, she's not being 100% honest with me. It sounds as though she didn't want to do safety, but they made her do safety. Then she's released from safety and she's in aftercare and she don't want to do that. So she starts doing her own thing. Felony drug court has a dual diagnosis program. And if she had mental health issues that were happening, they would address those. But if it's somebody who wants to do whatever they want to do, drug court is just not going to let you do whatever you want to do.
Correct. And that's why we are asking the court to consider what the probation office has recommended, which was to put her back in the DDR program, Judge, because I agree. I mean, I think she did better in that treatment program versus what we're talking about here on the safety and handing it over to her. She wants that. She wants that reinforcement of the
But she
mental
was
health
going
component.
But here's the thing, DDRF is in inpatient treatment.
She understands that.
I don't think she's a good candidate for probation. I mean, I don't think she's a good candidate. Felony drug court is a very good program.
Yes.
If you follow the rules, but sometimes people don't want to follow the rules. I don't think she's a good candidate for probation.
I believe this was only as far as I know, Judge, from what I can speak to is the report, this was the only violation that we have on her, and it was right after safety.
But see, here's the thing about that. Felony drug court, when people come back to this court from felony drug court, yeah, that's the only violation they have because felony drug court is sending them back. But when you're in felony drug court, they don't automatically kick people out of the program. They go through different steps, graduated sanctions. So they have technically, probably in felony drug court, she could have probably had 10 motions to revoke by now, but they don't do that. And I'm sure there's a reason why they did not approve her living with her parents. And part of that reason is because of the drinking. And they knew that they had probably already tried that before with her living at home and they told her no, but she wanted to do what she wanted to do. So now we're here, and I don't think she's a good candidate for probation.
I just feel, Judge, that the element of putting her straight into the state jail felony detention center, it just squashes the whole program of rehabilitation. I think she agrees. If it's going to mean more time, Judge, I think that the benefit would be there for her to do the mental health component. She clearly knows that she needs that help, as far as I know, and she's being fully, as far as I know,
Yeah.
you know.
But felony drug court was giving her that. She didn't want it. She wanted to do her own thing, and I don't think she's a good candidate.
Okay, I understand.
All right.
This is the breaking point. The state argues Deja had multiple chances, drug court, treatment programs, sanctions, but still broke the rules. The defense wants rehab, the state wants prison. What do you think is fair here? Another shot at treatment, or is the 2-year sentence the only option left?
The court is going to grant the motion, find you guilty, revoke. Now, the next question is, your state, you're asking for 2 years?
Yes, Judge.
All right. And state, why are you asking for 2 years?
Judge, she was in the felony drug court program. They did do graduated sanctions with her that included the DGRF and SafeP. And she just still could not comply with the terms of probation. So that's why we're asking for what we're asking.
All right. And what are you requesting?
Credit for time served. I believe she's already been there a little over 12 months. Doing the program, Judge, that's already 12 months that she's been in custody, I believe.
All right. The court will sentence you to 2 years in the state jail facility, give you credit for any time served, and not give her credit for any successful inpatient treatment. If she successfully completed DDRF, then she'll receive credit for that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
All right. You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you when you're released from custody. If you're still trying to find help with your mental health or maintaining your sobriety, if I'm still here, you come back here, I'll pick up the phone and call for a placement for you. All right, good luck to you. All right, you all are scheduled for jury trial today. You filed a motion for continuance?
I did, Your Honor.
All right, and why?
We have several reasons. We do have a motion to inspect and examine evidence, which if granted, I think will require us some time to inspect and examine that physical evidence.
Why wasn't that done before today?
Because, Your Honor, through preparation with my client, which was very limited because of the time frame which we represented him. This was information I had to develop over the course of jail visits, which I couldn't get within 24 hours. And so through prepping with my client, we learned of some evidence that might be, and I would expect strongly would be material and mitigating to the elements in the case. And so that's the reason why it wasn't filed earlier on in our representation of him, but it was filed before the jury trial date of
27th.
the 27th, yes.
All right. Anything else with regards to your motion?
I'm sorry, it was filed May 23rd, 2025, and I'll address that motion in a second. But the other issue is, Judge, we had requested missing discovery from the state, and since that request, we've gotten in about 12 videos that are pretty large, and even the state said it's a pretty big file that it took.
What missing discovery?
At this point, it's all been produced, but they are all recordings from SAPD personnel who are at the scene.
Okay.
And they're pretty large videos, Your Honor, and one of them I think includes the unmuted portion of the defendant's statements. And I also believe that that's going to have material and mitigating evidence for his defense. So it's really, really crucial for us to be able to review all.
All right, so review the video now.
Judge, these videos are an hour and a half.
Review the videos now.
Will do, Your Honor. And then the other issue with the motion for continuance is, the other issue with the motion for continuance, Judge, is that to prepare an adequate defense for him and to avoid issues of this case being appealed for ineffective assistance of counsel.
People love to throw around ineffective assistance of counsel. This case has previously been set. He had another attorney. It was set for jury trial, and your firm decided that you were going to represent him and get on a case knowing that it was set for trial. So if you all want to throw your swords on ineffective assistance of counsel and file that with the appellate court, that's completely up to you. Next
I
one.
understand that, Your Honor. The issue is that it is very apparent to me that because there was so much missing discovery that was never requested, that there was not adequate prep work by the prior attorney. And that's why, unfortunately, and I don't want it to be held against him, it's taking us so long to put everything together and figure out the missing pieces.
Oh, no, name the parties who you're saying didn't complete adequate discovery.
Name the parties that
Oh, yeah, who are you
The
talking
state.
about?
the state.
Okay,
So the issue, Judge, is that I don't think that this should be held against him. He's facing substantial jail time. It's an enhanced first degree possession with intent to deliver. And so those cases, they require a lot of links, a lot of connecting the dots. And so my argument for the continuance would be that we definitely need some more time. Just
all right,
because
the
of
video
nature.
is like an hour. What did you say, an hour and what?
So the 12 videos, each one starting at least at about an hour and a half long.
All right, so y'all need to watch the videos today. He's here, you're here, watch the videos. Next point.
We'll do, Your Honor, but the other point is that this is a case that has a lot to it. And so it's not just a regular, like a DWI third or another felony that you could get ready for very quickly. And so given the nature of this case and the prep work for it, that is a little bit above and beyond another felony in this court. That's also the reason for the continuance.
All right, but you all knew that this was set for jury trial. And so you all chose to do it. You've been given your 10 days. So what's your other grounds for a motion for continuance?
That I don't have any other grounds for my motion, Your Honor.
All right, so you all need to look at the whatever video she says he needs to see. If you will load it up so she can watch the video with her client.
And Judge, I tried to do that when I was here about a week and a half ago, and the state never was able to give me the video because they were too busy. And so
Well, do you see anyone else here now? Load up the video so she can watch it with her client.
Don't you have access to it now?
we requested, but it doesn't come over right away.
So you
It
don't
takes-
have it?
So the other issue, Judge, is we have a motion to inspect and examine physical evidence. The state tells me that they're not opposed to it.
Well, you all should have done that before your 10 days. You had plenty of time to inspect evidence, so.
Okay, is the court going to rule on it?
Oh, yeah, you can expect whatever evidence you want to inspect, but I am not granting a motion for continuance because you all have not inspected evidence that was always available.
Would you like a copy?
They've given me copies of your motion. So state, she wants to inspect evidence. Is there any other motion?
Judge, it's just, there's two motions for each cause number.
Okay,
So I just wanted to see if we could get your signature on both cause numbers.
okay. And other than that, is there any other motion?
Yes, we have a motion to require disclosure of all informers relied upon and for production of said informers.
All right, so what are you basing that? And you're speaking of a confidential informant?
I believe it is, Your Honor.
All right, so there are certain grounds legally where you're allowed to that information. So what are you basing that request
So
on?
Judge, there's a reference to an anonymous tip by the detective in this report. And so I don't know, I think we need to call him in to at least get some testimony about what the anonymous tip was. And generally speaking, like, what's the nature of it? What did it reveal? And is it somebody that this person has worked with in the past? Because that's all I have is that it's an anonymous tip. There's no other
Stay.
information included there.
I can call Ramirez, see if we can get him here.
Okay,
And then we just have we just have other pretrial motions that I
Alright,
expect
sure.
we could argue.
did you all confer with the state on your pretrial motions?
I haven't. Does the court want to take them up at this time?
Well, I mean, don't you want to confer with the state to see if they're in agreement with your motions? If you don't want to do that, I will hear them. But it would seem it would be economical to see whether or not the state agrees with your motion, then maybe you wouldn't need to have a hearing on it.
Yes, sir.
Yeah. She says she has motions Do you have copies of those? The other ones? I only have two. The only one I have is the inspection motions. I don't have the rest. I mean, how long has this been sitting around?
January.
Oh. Like, since January, why am I just not receiving it?
I think, try to follow up on it, so if they never received it. So. I will take it to them.
No, I'm just signing it. I don't, attorneys shouldn't have to wait months to get a voucher signed or paid. All right, while y'all are going over these motions, you need to start watching a video with him, and I'll take your motions up after you finish watching a video.
The prosecutor doesn't agree with the two motions.
All right, so go ahead and watch the video so we can get that out of the way. These motions will only take 5 minutes, maybe.
Okay.
All right, thank you.
I'm sorry, am I showing him the video on the prosecutor's laptop or?
However you all do it.
Okay, that's the only way to do it because we don't have the video.
All right, so this is the thing. If you all want me, I will step from the bench. I will load up the video so that you can watch it. I don't see that as my job. So you all need to talk to each other. I don't know why it's so hard to talk to each other and get things done. You say you want to see a video, then you're going to watch the video, but this case is going to trial today. We're doing jury selection, and that jury selection, I'm giving y'all this morning to do your videos. That jury selection is happening this afternoon. So either y'all want to get together and look at the videos or you don't, but at 1:30, we're doing jury selection.